Atty. Cayosa, IBP was a petitioner here. Now, over the course of the day, some people have been calling it a partial victory. Government is also claiming it as victory. They're saying, 58 out of 60 provisions. Constitutional naman pala yung ano. On balance, on balance, how do you appreciate it?
Well, we find it a very limited victory for the petitioners. Unfortunately, the major provisions of the law, which we thought and we sought to be unconstitutional, hindi naman dineclare unconstitutional daw ng Supreme Court. I say daw because we are only reacting to what is publicly announced by the PIO of the Supreme Court. We have read the complete decision, including the concurring and dissenting opinions.
Yes, sir. Pero sir, you characterize it as a very limited victory. When you put it that way, kasi it almost sounds like a defeat. Kasi if you look at everything in balance, the major provisions that were being questioned were never touched by the Supreme Court. Section 29 on warrantless arrest. Section 25 on designation, ginalo lang doon yung supranational jurisdictions. Section 4, yung ginalo lang doon yung proviso on rallies and dissenters and all that. But the general definition of terrorism still remains. Para lang hindi nakakalito sa mga tao, ano talaga assessment natin? Is it kanino pumanig bale ang Korte Suprema?
Well, I would say the decision as given in brief to us is in favor of government. Titignan natin yung dalawang dineclare na unconstitutional. Of course, they're very important. But not as important as the other provisions that were questioned by the 37 petitioners. Well, as far as standing is concerned, we're also thankful na hindi naman tinechnical na walang standing because that is also a possibility. So, kinonsider naman ang petition, it was decided on the merits.
Okay. So, ano yung pinakamalaking issue ninyo doon na, kumbaga yung pinakamalaking defeat nyo kasi the human rights groups are pointing out particularly to that 24 days of detention, no?
That's one. That's one. The 24 days of detention without being charged in court. The other one, which is very glaring, is that the law gives the Anti-Terrorism Council, an executive branch of government, the power to authorize arrests, which under the Constitution and jurisprudence is reserved to the courts. The third one, which is very basic, is the definition of what is a terroristic act under Section 4. We find those very vague, unlike other anti-terrorism laws, which have predicate crimes like murder, homicide, arson, etc. Dito, any act is considered, if the intention is to create havoc or sow fear among the populace. So yung intention, it's largely within the imagination of the law enforcer, hindi well-defined. So ito yung sa tingin namin napaka-importante, pati ho yung right to bail. Because there's a provision there that denies the right to bail, even if the penalty is not life imprisonment. So, to our mind, these are the more controversial and more patently unconstitutional provisions. Unfortunately, mukhang hindi kinatigan ng Supreme Court ang mga petitioners dito.
In the same way that not the entire law was struck down as unconstitutional. In fact, only a minority of its provisions. When we talk about Section 4 itself, it was not also Section 4, which defines terrorism, that was completely also struck down. It was just parts of Section 4. But how vital were those parts? Because definition obviously is foundational to the entire law. Were these parts foundational as well, or potentially foundational or not, to Section 4?
Well, You're correct. Very important yung struck down provision. It's actually a qualifier to a provision in the law. But to our mind, and we welcome that, make no mistake about it, we welcome that because it upholds the freedom of expression. Kayo na rin sa media, you should be very happy with that because tinanggal yung qualifier na yan. So at least we get some protection from the Supreme Court on that aspect.
Pero sir, how does that, actually kasi it reads more like a qualifier to a qualifier eh. A double qualifier, di ba?
That's correct.
So with that qualifier to the qualifier out already, how does the definition read now? In layman's terms, ano ba yung pasok ngayon sa terorismo kung ngayon tinanggal na yung qualifier to the qualifier?
Well, marami pa rin sa nakalagay sa batas. Karamihan, pasok pa rin no, sa definition nila. No? Yung any act, basta ito lang kasi nag-focus dun sa yung expression, public expression, mga
Dissent,
rally,
mass
mga
protests.
Yes. Kasi nakalagay doon na hindi yan daw yung freedom of expression, ay kayo sa media, yung nagrarally, okay lang yan. As long as there is no intent to harm or to cause harm on the part of the speakers or the rallies, yung intention nasa utak at saka sa puso eh. Paano mo malalaman yan? So, when you start punishing the intention, then you give too much power to the law enforcer.
Yes, sir. Pero sir,
Yan, tinanggal ng Supreme Court yan. So, regardless of your intention, kasi hindi mo naman malalaman, makikita talaga kung yung intention, kung mag-express ka ng iyong paningin sa gobyerno, kontrahin mo man yan, batikusin mo man yan, that cannot be a terroristic act.
I'm